Hello. Hello, Emmanuel.
Um, Hello, Toy. Good morning.
Yes, good morning.
Morning. Permit me. I'm just trying to set up here. Okay. All right. Good morning. Good morning, everyone. Good morning, Toy. Welcome to the webinar of Aspen Sahel Legal. Today we'll be talking about dispute resolution clauses in agreements. So the topic and our theme revolves around why you should pay attention to dispute resolution clauses in agreements. So with us today, we have an expert in the field. We have Mr. Toib Amuda, who will be taking us through essential parts, intricate parts of what we should look out for in dispute resolution clauses. He will also take us through the recently decided case of P&ID versus the Federal Republic of Nigeria, and how the dispute resolution clause almost basically botched the entire process, and how parties basically slogged it out in that case, looking at a provision where there is no seat of arbitration mentioned in an arbitration clause. So without further ado, I'll take us through the introductory part. Basically, I'll talk about the firm, Aspen Sahel Legal. So Aspen Sahel Legal is a corporate commercial law firm in Lagos, Nigeria. And of course, that's where we are based. And we're providing first-in-class legal support through, of course, the latest market knowledge and legal insights to our clients. We basically are focused in the areas of venture capital and private equity transactions, investor and startup advisory, mergers and acquisition, technology, energy, media and entertainment, taxation, and real estate. We also guide on strategic partnerships and collaborations. And of course, we advise on market entry transactions into several industries and sectors in Africa. For now, we are regulated by the Nigerian Bar Association and the Nigerian Body of Ventures. And this is in line also with our vision, which is to accelerate the growth and transformation of the next generation of African businesses into global companies by providing world-class legal support. So once again, I would like to thank Mr. Amuda for agreeing to be on this call, this webinar, and to also give us or impart on us his knowledge on this in this field, basically. So permit me to share my screen so that I can take us through my own part of it, because I also basically do an introduction, just lay the foundation upon which Mr. Toib would take it from there. So, Mr. Toib, I would like to share my screen. Okay. Is it up now?
Yes, I can see a screen.
Okay, thank you very much. So, so why you should pay attention to dispute resolution clauses in agreements? All right. Okay, so the nature of disputes, yeah. Disputes arise in a series of circumstances and in a number of situations. As humans, disputes are inevitable. The fact that we exist, the fact that we live, and we carry on transactions on a daily basis, there will always be the need basically for us to resolve disputes as they arise. In commercial transactions, there are several circumstances basically in which disputes arise. We have labor disputes, which involves, for instance, the over disputes, even employment law, right? That is a dispute between employer and employee. With regards to intellectual property, we have disputes around copyright, trademarks, and patent infringement. For instance, there is a decision in Zoom versus Zoom, where the courts basically held that the name Zoom, right, not registered under a particular class, does not infringe on, of course, the Zoom that we know, right? We have contractual disputes. We have disputes with regulators. For instance, we have the CBN versus RiceVest case, where the court basically ordered that the bank accounts of RiceVest and other fintechs should be unfrozen. We also have customer and user related disputes with regards to, let's say, companies or startups and their users, right? We have, especially with regards to consumer rights, generally, we have data protection and data privacy disputes. We also have investor related disputes. For instance, we have the case of P&ID versus Nigeria, which we're going to talk about in this conversation. Dispute resolution options they vary basically. In our legal process, we have the courtroom-driven process and non-controlled courtroom-driven process, which is basically through alternative dispute resolution mechanisms. For courtroom-driven process, this is essentially litigation where the parties go to the courts in accordance with the provisions of the law, right? The Constitution of Nigeria, and of course, like looking at where the dispute is in Nigeria, if it's in the US, we look at the United States Constitution, and also following the rules of courts, right? The practice of courts now is for them to encourage parties to resolve disputes through ADR before it is essentially before they bring the matter to the court. So the court actually encourages parties to resolve disputes using alternative mechanisms. And also, of course, there are several jurisdictions of courts. I won't go much into that. We have the Supreme Court in Nigeria, for instance. We have the Supreme Court, which is the highest court of the land. We have the Court of Appeal. We have the Federal High Court, State High Courts, National Industrial Courts. Also have magistrates and district courts. So that is for the courtroom-driven process. For the non-courtroom-driven process, we have alternative dispute resolution mechanisms. So here we have several means, right? We have negotiation, we have mediation, we have conciliation, we have arbitration, we have early neutral evaluation, and of course there are other ones which I didn't mention, but these ones are basically very important. So what is negotiation? So under negotiation, parties to a dispute come together, right, to have a conversation on how they can basically resolve their disagreements without the involvement of any external third party. So the parties come together to talk it out, right? For mediation, a neutral and impartial third party is invited by the parties, the disputing parties, to help them reach their own mutual settlement and agreement. So here, they call someone who is neutral, who is impartial, to help them reach an agreement, which of course they would agree that it is binding upon them, right? For conciliation, which is similar to mediation, conciliation basically involves them bringing a neutral third party who uses, of course, his best endeavors through opinions and suggestions to bring the disputing parties to involuntary settlement of their disputes. So for the difference here is that conciliation, the conciliator now can basically give them suggestions, can also give opinions, but the mediator essentially guides them without necessarily suggesting to them on what to do or telling them exactly what they should settle for, right? So that is the difference between mediation and conciliation in layman terms. So for arbitration, the parties to a dispute submit to a third party called an arbitrator or an arbitral tribunal for the resolution of their dispute. So essentially, they go to a panel in a courtroom-like setting, right? Especially when they want to go to court. So the tribunal basically decides on the dispute after listening from both sides. They give their award, right? The arbitral award, which is binding essentially on the parties. So for early neutral evaluation, right? So before the parties go into litigation, before they call someone who is neutral, usually a judge or a retired senior lawyer or retired judge, and yes, the parties' positions, the position of the parties and their submissions. And from there, he states his view on what is likely to be the outcome of the trial. So this is before they even get into court. So this position of the neutral evaluator influences the parties, right, on how they can essentially settle that dispute before going through the rigor of litigation generally. So now going to dispute resolution clauses in agreements, Mr. Toeb is going to break it down for us and take us through it. They are like rules, yeah, in a contract that help parties figure out what to do if they disagree. So the clause is basically a provision in the contract that spells out rules on how the parties can resolve their disagreements. It's basically like a roadmap for solving problems that everyone doesn't, basically, so that they won't go to courts, right? And of course, we know that courts can be time consuming, they're expensive and all. So it's like having a plan in place, like I put here, to talk and work things out instead of arguing in a big, serious way in court. So that is why parties decide to have dispute resolution clauses in agreement, so that if there's a dispute, they already know the next step to take. They already know what to do. So this involves, for instance, provisions that enables them to talk it out. Yeah, that is talking it out. This is negotiation. So a properly drafted dispute resolution clause gives the parties ample time and opportunity to first try and negotiate, right? So talking and figuring things out nicely. It's like, for instance, you and your friends having a disagreement and deciding to do, before we do anything that is overboard, let's sit down and have a chat. Let's find a solution to this disagreement, right? So it also involves them introducing a clause in the event that negotiation fails that enables them to basically bring in someone neutral. So this is mediation now or conciliation, like a teacher, right? To help them understand each other better. The mediator doesn't decide who is right or is wrong, but it only assists them and helps them to find a solution, basically, to the dispute. Then, if that doesn't work out, they cannot decide, okay, let us get, I describe as a fair judge. So this is basically arbitration. So if they still disagree, they bring in someone like a judge called the arbitrator who will make a decision, right? This decision is final. So like in a game where a referee basically decision is the last word. So the decision of the arbitrator in that case now is final. So these are the things we should look out for, right? In a dispute resolution agreement. So that is it from my end. I hope I've laid a good enough foundation for Mr. Toib to basically take it up from there, which is basically the meat of this conversation. He's going to take us through several case studies and all. So thank you very much, Mr. Toib. Thank you very much, everyone, for listening to me. So, Mr. Toib, you have the floor. Yeah.
Thank you very much, Emmanuel, for setting the foundation of what we are discussing today, which is very important. As you rightly said at the beginning of the webinar, dispute resolution clauses sometimes now, parties see it in contract as an afterthought, or just a boilerplate clause in a contract, which is not supposed to be. We've seen in recent times that this has proven otherwise, and that dispute resolution clauses are now actually some clauses that should be given more attention than we currently see. So basically, I will be talking about what we've seen so far in practice, and how parties can indeed avoid situations such as this losing time, losing money. These are very, very important factors that parties need to consider when drafting their contracts. So let me just also share my screen, because presentations now are much more interesting with screen shared. So just a minute. Okay. Okay. So I don't know if my screen is visible.
It's clear, it's visible.
Yes. Okay. Okay. So I can still. I hope I'm still.
Yes, I can see.
The presentation is still on the board. It's still on the screen. Can you still see my screen?
Yes.
Okay. I'm trying to see. Just a minute. Just let me put this in full screen mode, please.
Okay, I think it's because of it's a PDF document, so it's not coming up in full screen mode. You can only show the PDF.
Okay. But you can see my screen. Just the PDF file, I believe.
Yes.
Okay. Why you should pay attention to dispute resolution clauses? The first port of call is the P&ID case, right? And what are some of the mistakes that we've seen? And I guess I believe this is another document. Just give me a minute. Let me get the proper document, please. Yes. Let me get the proper material. I believe that was another document. Okay. Maybe the PowerPoint. Maybe that should be better. Yeah. Just 1 minute. Okay. Just a minute. Document. Okay. Yes. Okay. That's good. Okay. Now let me share this. This is much wider. Okay. I believe this is much wider. Okay. I believe this is clearer. Okay. Okay. Thank you. So the first part of call is we look at some of the case studies that we have seen. And some of the mistakes that I can identify, it's, the first one is missing elements or missing terms of contract. And, when I talk about missing terms, I mean parties missing certain vital terms of the dispute resolution clause itself as it is. And some of these terms can include the seat of arbitration, the place of arbitration, notification of the dispute, method of appointment of neutrals. These are some of vital terms that parties, most times miss in contracts. For instance, we look at Article 20 of the Gas Supply and Processing Agreement in the case of Federal Republic of Nigeria and Process and Industrial Development, which failed to specify the seats of the arbitration. Now, this particular incident led parties to make submissions to the tribunal, and this came after a proceeding has been issued in the Nigerian courts, basically challenging the seats of the arbitration. Nigeria arguing that the seat of the arbitration was Nigeria, and P&ID stating otherwise, that the seat of arbitration was in London. And this actually now led the tribunal, to actually make a procedural order to address the parties' contentions on the seat of the arbitration. And then the tribunal found that indeed the seat was London. So this is just one missing element that then led to this protracted case of arguing whether the seat was Nigeria or London. And of course, this is something that should have been avoided had this vital element been included in the contract, right? And then, of course, there was a further hearing, of course, in the English court as well, to determine the seat of the arbitration. So this is one of the key, one of the things to avoid. Secondly, we look at conflicting clauses of dispute resolution clauses, or multiple and conflicting clauses. And this commonly occurs actually in construction and engineering contracts. For instance, where parties adopt the FIDIC contract. You will notice sometimes where parties adopt the FIDIC conditions of contracts. In the main contract, it's going to state that okay, you can have you're gonna use the FIDIC contracts as part of the conditions of contracts. Meanwhile, these contracts themselves contain additional dispute resolution clauses. So it is very important that when adopting FIDIC contracts or when using FIDIC contracts, that it is, the clauses, the dispute resolution clauses in those contracts are reviewed, to see that they align with the terms or with the dispute resolution clause of the main contract. So these are some things that we also see because sometimes we have some situations whereby a party who wants to actually, litigate the dispute, we say, okay, I'm going to rely on the dispute resolution clause in the FIDIC contract, while another party will say, okay, I'm going to rely on the dispute resolution clause in the main contract. And a way to avoid this is to say that, okay, the terms of the main contract supersedes the dispute resolution clause in the FIDIC contract, or to ensure that whenever you are adopting FIDIC contracts, you ensure that the dispute resolution clause in the main contract actually aligns with the dispute resolution clause in the FIDIC contract. So these are some situations that we've seen, and a way to actually avoid this, of course, is proper drafting of the contract. Now, proper drafting itself, it's not just to have a contract that's, okay, it's not just to have a contract that says, okay, we're going to negotiate or we're going to go to court, whether the Nigerian court or the English court, but to actually have a contract that actually specifies, the totality of what the parties envisage in terms of dispute, and this can be a multi-tiered dispute resolution clause. And the starting point, of course, when drafting this kind of clauses is the notification. So a party who desires to submit a dispute for resolution should commence the dispute by providing the other party with a notice of dispute. So this is a notification process. Secondly, you may want to look at adopting negotiation. through direct negotiations. And when you're including a term that involves direct negotiation, you want to ensure that you have the term that says that individuals with decision-making authority are to attend such negotiation. Because what is the effect of just including a negotiation clause without actually reaching a settlement when parties are sitting to negotiate? So these are something that you want to consider when you're having situations such as dispute resolution clauses such as this. And then again, you also want to look at the time frame for the negotiation. How many days? Is it 30 days? And are we able to resolve it within 30 days? If you're not able to resolve the negotiation process or the dispute through negotiation within 30 days, then you may also want to adopt mediation and conciliation. Now, mediation, Emmanuel has beautifully defined what that is. This is where a neutral third party comes in to mediate the dispute between the parties to try to attempt a settlement between the parties. Now, you also want to make sure that whoever is attending the mediation also has decision-making authority. So this is also something that you want to consider, because what's the essence of actually attending a mediation process and paying the mediator when the people who are attending the mediation have to be making phone calls or have to be and which discusses delay to the mediation process. So you also want to make sure that in the clause, whoever is attending the mediation has decision-making authority, or at least even if there are going to be any phone calls that are going to be made, such phone calls or such a communication can be made as swiftly as possible, because the idea about mediation also is that the mediator will be paid. And, this also had to cost where parties extend over the time that has been agreed between the mediators and the parties. And now in Nigeria, the mediation is now governed by the Arbitration and Mediation Act 2023. So this is something which is quite important, which means that negotiated settlements are now enforceable, between the parties. Now, going on to if parties fail to, resolve the dispute by mediation, you also want to consider, arbitration, which is something that commercial parties. This is a notice, which is something that commercial parties actually wants to take note of. So, and the first part of arbitration, of commencing arbitration, is indeed the notice of disputes. You want to see that whenever mediation fails, or after 30 days when mediation fails, parties are able to resolve these disputes by arbitration. And again, why do we say arbitration? Because parties may decide to go to court, but then you want to consider the issue of time. There are some disputes that are not arbitrable, not mostly commercial matters. Commercial disputes are mostly arbitrable. So you also want to consider the time frame of selecting whether courts proceeding or arbitration. Most commercial contracts adopt arbitration, which is why I'm focusing on that. Notice is the first option you want to look at when you are inputting a term of arbitration. You must also note that there are some instances where you have unilateral option clauses. And what this means is that it says that just a single party has the right of giving notice or of commencing arbitration. Now, this depends on the terms that the parties are able to reach. Because sometimes someone will say it's unfair when a single party is able to commence arbitration. But the idea is it depends on negotiating power of the parties and what the parties actually agree to. So unilateral option clauses sometimes, says that just a single party will be able to commence arbitration. And then you want to look at the rule, which is something important. You want to look at the rule that you're adopting in your arbitration clause. What rule are we selecting? Under which rule will the arbitration be conducted? And, you have various rules. You can either adopt the UNCITRAL rules, the ICC rules, the LCI rules, or you can say, okay, we'll just go with the Arbitration and Mediation Act. Now, the impact of the rules is that each rules contain their own specific guidelines and how the arbitration will be conducted. So, for instance, UNCITRAL rules provides for the appointments, and maybe you want to look at which rules provide for expedited proceedings, which rules, how can we get interim relief on time? You want to look at the institution. How can the institution assist us in, administrating this dispute, and this goes into issues of holding of funds. So, for instance, in the case of the Arbitration and Mediation Act, you don't have the situation whereby, oh, there's an institution that will administer this arbitration for you. You can look at, you want to select the Regional Center for International Commercial Arbitration. You want to look at the LCIA to see who is the best institution to actually administer this arbitration on our behalf. And if you just want it to be an ad hoc proceeding, you might select the UNCITRAL rules and adopt the UNCITRAL rules, as you please. So the rule is also something to consider when drafting the arbitration clause in the arbitration provision in dispute resolution clause. You also want to consider the place. Now, this is something that usually causes conflict. And again, in the P&ID case, going back to that, what the parties actually selected was, the place of arbitration. No seat was selected. Now, place now is a physical location of the dispute, the physical location of the arbitration. So that is the place of the arbitration, the physical location of the arbitration. So you want to look at where are we selecting? And if the thing about dispute is that, or arbitration is that, it can actually be, it can take place anywhere. So parties can select a different seat, which I will get into shortly. But the arbitration hearing itself can take place in another place. And of course, it can also take place virtually. I've had a number of over 5 arbitrations that I've had virtually. And the parties we didn't see each other. The tribunal didn't see the parties. And the dispute was resolved and the awards were rendered. So the physical location is something you also want to consider. You want to consider transportation, security. These are things that you want to consider when selecting a physical location. And the Arbitration and Mediation Act now provides that where a place is not selected, that is a physical location, the tribunal may decide that. And also going to the seat of the arbitration. Now, the seat itself is the legal place, the legal home of the arbitration, and provides supporting framework. Now, the importance of the seat is that it governs the challenging the awards. Maybe an award was issued and a party was not satisfied with the holding of the tribunal. The seat is where you can challenge that. Why is this important? Because the court of the seat actually supervises the hearing itself, the jurisdiction of the tribunal. So the court of the seat exercises supervisory jurisdiction. So why is this also important? You want to look at how fast do the court operate, how effective are the court system in this particular seat. And then interim relief also goes to the seat of the arbitration. You want to look at how fast can we get interim relief. Now, going to Nigeria, the Arbitration and Mediation Act 2023, Article 32 now says that where parties have failed to select a seat, Nigeria will serve as the default seat of the arbitration. So, moving forward, you want to look at the appointment of the arbitrator, which is another important point that needs to be considered, the appointment of the arbitrator. Now, appointment is something that parties sometimes, just adopt as they look at a boilerplate contract and then they copy and paste appointment clauses, but you have to be specific about even appointment. So the manner of appointment of the arbitrator should be considered, the time frame of appointment, the qualification of appointment of the tribunal, and the number of arbitrators depending on the value of the dispute. So sometimes you can say, okay, maybe your dispute, if it's if it's less than $5 million, you're going to have a single arbitrator, and if it's more than $5 million, you're going to have 3 members of the tribunal. So this is something you want to consider. Fees and costs. Are the fees and costs of the arbitration, are they going to be paid? And when will they be paid? Who will bear the loss of the arbitration? Are you adopting the loser pays principle? That is, whoever loses the arbitration will pay the cost and fees of the parties. So this is something you also want to consider. Award. What is the timeline for rendering the award? What is the timeline? Do you want to specify that the arbitrator should render the award within 30 days of the hearing, or you want to say within 90 days? Depending, the parties can actually agree to this and the tribunal will follow the agreement of the parties. Finality of the award. You want to insert these terms in the contract so that parties understand that the award is final and binding and that they waived any right of appeal. The governing law of the dispute of the dispute. Now, this is something that sometimes conflict, and you want to be careful when inserting governing law. You want to note the doctrine of separability when it comes to arbitration, because an arbitration agreement itself, it's separate from the main contract. And the law governing the contract can actually be different from the law governing the arbitration agreement. So as you are saying, this contract will be governed by Nigerian law, you also want to be specific about the law that actually governs the arbitration clause. So the law governing the arbitration agreement should be specified, and also you want to note the Convention on International Sales of Goods, CISG, and make sure that you either apply, if you don't specifically exclude the application of the CISG will automatically apply, especially in countries that have adopted the CISG. Right. So this is something you want to consider internationally when you're drafting contracts, that the CISG will not apply to these contracts. That must be specifically stated. Now, and finally, we look at language of the arbitration. This is something that, you can sometimes parties overlook, but indeed it's important for you to actually, state the language of the arbitration. And of course, and state that documents that are produced in foreign languages should be interpreted, right? And again, who bears the cost of interpretation, the cost of the interpreters. So this is something you also want to consider when you're drafting your arbitration clause. Now, enforcement, you want to make sure that parties are able to enforce the arbitration agreement. Now, this might not necessarily be put in a contract, but there's nothing that says you can't include enforcement clauses of an award. And this means that saying that parties can approach any country that has adopted the New York Convention, to enforce this award. Where a state has not adopted the New York Convention, such a state can actually have its own laws, its own domestic laws that deals with enforcement of foreign awards. So, but majority of states now have adopted the New York Convention. And then, of course, you also want to specifically state that in the case of, let's say, a state and a private party, that the state has waived its immunity. This is something that the laws of various nations have provided for, where a state has entered into a commercial contract, they automatically waive their state immunity on their assets, for enforcement against their assets. So this is something you also want to state in the contract. Now, and then, concluding, where appropriate, businesses may consider reviewing current and past contracts to ensure they have appropriate and legally binding dispute resolution clauses, right? Now, what are these stages you want to look at? You want to start at the drafting stage, because this is the most vital point when preparing a contract. But that doesn't mean there can't be a review and amendment. So, we can assist with review and amendment of the contract. And of course, addendum, there can also be addendum to the contract, since, there are options of amendment to the contract where it's better to amend the contract now, immediately after this webinar, to amend the contract now than wait till maybe when a dispute now arises to amend the dispute resolution clause, because it's always good when parties are still friendly with each other and in good commercial relationship, to be able to amend the contract and review the provisions of their dispute resolution clause and see that, okay, these things are quite about aligning with what we actually want when a dispute arises. So this is something you want to consider, and it doesn't mean you can also have an addendum to the contract, which will amend the main contract that you have between. So I think that's all for me. Thank you once again for having me, Manuel, and I hope that our audience have been able to learn a thing or two. Thank you.
All right, Toib. Thank you so very much for that wonderful presentation. For now, we'll have to basically look at some sample clauses, some sample arbitration dispute resolution clauses in agreement and what it looks like. So I'm using my phone now because I typed with my phone. So let's see if I can share what I have here with my phone. So when you're drafting an arbitration clause, you can look at what you can look out for, basically, with regards to what it should look like, right? Toib has gone through some of those things we should look out for with regards to how the seat of arbitration and the venue of arbitration and the language of arbitration. And also I'm going to share I'm going to share now. Okay. Screen. All right. Okay. So can you see my screen? Hello? Hello, Toib. Can you see my screen? Okay. Hello, Toib. Okay. Can you see my screen? Okay. I can't hear you anymore. Okay. I can't hear you anymore though. Can you hear me? Oh boy.
Good. Oh, I can hear you. I can hear you.
Okay. So I think, look, I shared with you. So maybe you should try share from your end. Basically, I don't know. I think I'm having difficulty.
Okay. Yes. Okay. Let me share it from my screen then, if you want to use it. Okay. Let me share it from my screen then. Okay. That's I believe that's the sample. Oh no, the sample dispute resolution clause.
Yeah.
Okay. Okay. Okay, just a minute. I'll share the screen. Okay, yes, I have it here. Okay, I believe this is the document.
Oh, absolutely. Absolutely. So can we all see it? Okay. All right. So this is the sample source, right? As Boyd mentioned, fantastic, fantastic. So we first of all we start from the very beginning with a notice, right? I didn't include a clause for notice here, but before it even starts, there has to be a notice. So the first stage is for the parties to become table, like when you go for the to negotiate. That's one thing it has to be there. They can draft it in any way, right? And it's the binding. But this is like an example of a comprehensive way, right? Such that it will not lead to unnecessary expenses, right? Like
You may want to move to your mic more, Emmanuel. It's quite low.
Okay, is it better now?
Yeah, it's much better now, yeah.
Okay, over divergent views on how the clauses should apply, just like in the case of P&ID versus Nigeria, where there was a dispute with regards to the seats of arbitration. So it is better if the parties basically are very, very clear on what they basically intend. So for the negotiation, yeah, so upon the emergence of any dispute under or in connection with this agreement, the parties commit to engaging in good faith negotiations promptly after receiving, written notice of the dispute. So there's a provision for written notice, right, of the dispute. Then the parties come on table to basically negotiate. So for mediation, so the parties can decide to go either use mediation or arbitration. So should the dispute persist beyond, in his presentation, Toye gave an example of 30 days, but the parties can decide to give a longer or a shorter period than looking at the days and the nature of the transaction. So let's say 30 days, for instance, of negotiations without resolution, the parties agree to submit the matter to mediation under the auspices of, so we can use a mediation institution, right? It could be, we could use let's say the Chartered Institute of Arbitrators, Nigeria, UK, or we can decide to use a mediation body. We can go through the Lagos Court of Arbitration, for instance, or an institution that does this. Or they can even decide that, okay, you know what, let's appoint someone neutral who they both trust, basically in their industry, maybe in construction or in engineering, to basically act as a mediator for them. So the mediation shall adhere to its rules, and the parties will collaboratively select basically a mediator. So it's better when the parties basically select an institution with clear rules on mediation. Yes. So of course, there's also of course clauses on arbitration after a particular number of days. So the arbitration must basically be very clear where the rules that they're going to conduct the arbitration in, right? They have to provide also for the seat of arbitration, the language of the proceedings, and of course, the arbitral award, stating that it is final and binding. So this has to be stated in arbitration. So for governing law, right, of course, we have to basically state the law that the contract basically be governed by. I just had to include it there, right? Because this is usually a separate clause in an agreement, or sometimes it can be included as being a part of an arbitration clause or a dispute resolution clause. So this agreement shall be governed and construed in accordance with the laws of, I had to provide the Federal Republic of Nigeria, excluding any conflict of law principles. So the reason why parties basically exclude conflict of law principles is to basically ensure that if there are other rules or if there are other laws that govern such an agreement, especially with regards to cross-border transactions or international transactions, those laws, right, won't apply to that agreement. Rather, the law that was specifically mentioned to that agreement, in that agreement, is what is going to apply. So the venue of arbitration, like Toib explained, is more or less like the place. So a clause has to be provided for that. Then expert determination, right? So if they bring in an expert, basically, right, just like for any neutral evaluation, and they decide, okay, this expert should basically make a determination on a binding determination, then in that case, it's going to be binding. So for escalation protocol, right, so the parties can also decide that, okay, way before they even decide to start negotiating or whatever, they can decide to escalate to the management or representatives of their if it's a company, their companies or people with decision-making power. So basically, so that they will be able to resolve the dispute as early as possible. Toib also mentioned about costs, right? How they bear their costs. So we have to provide a provision for costs or attorney fees. Both parties can decide to bear the cost. They can also decide that, you know what, we are going to split the cost. They can decide that, okay, the losing party bears the cost. So there's a way they can draft it, basically. And of course, the survival clause, the clause has to basically survive the expiration of the agreement, such that even after the parties have fulfilled their conditions and the obligations under the agreement, that in the event that maybe there's a future dispute, so that the parties cannot just go to court. Rather, it's that clause basically survives the agreement, so they can go through the normal procedure of negotiation, mediation, then of course arbitration, so as to make the resolution of that dispute easier. So I guess that's it for a sample clause, right? Of what it should look like. Basically, it has to be comprehensive enough, and it's of course the what the parties want should be very, very clear in that agreement. All right, so so this is the time for Q&A. So if you have questions, we'll be ready to take them now. You could just signify, you can put your questions in the box, in the chat box, so that we can take them. Yeah, so thank you very much. Okay, someone mentioned that it would be great to have a sample of the clause. Okay, that's fine. We'll share to the emails for those that are registered through the link. We'll share with everyone. We'll share the slides and a sample of the clause. All right. So, any question?
I believe if someone wants to ask a question, they can either actually unmute the mic and ask the question. So, if they're willing to do that, so can actually unmute the mic and speak. Yes. Thank you.
Hello, can you hear me?
Yes.
Good morning, Tohi. Good morning, Emmanuel.
Good morning.
First of all, I want to say a big thank you for organizing this webinar. I have been looking forward to sitting in on it, and I'm very happy that I was able to make it. So let me quickly get to my question. There is a particular law that Tohib mentioned when I didn't quite get the law, but he said when he was talking about laws that apply to arbitration, he said that it has to be specified in the contract that this particular law should not apply, but that because when it's absent, that law will apply. I don't know if the question is very vague, I know, but that's the one part that I missed out on that I really want to get. I don't know if you can help me, or perhaps you remember that exact part, or maybe you have the clearer understanding of what I'm trying to
ask. Yes. Thank you very much, Nelo. The law I was talking about is the CISG. And
yes,
the CISG,
yes,
the CISG, this is the Vienna Convention on International Sales of Goods.
Okay.
Yes, so the provision of the CISG, again, to countries that have ratified, I don't believe in the case of Nigeria, that Nigeria has ratified the CISG. Nigeria is not a party to the CISG, hasn't ratified the CISG, right? So the idea of the CISG is that a country that has ratified the CISG, it's what the CISG does, it's a contract for international sales of goods. So it deals with quality of goods, quality of goods, time frame. You can do some further research on this as well. So the idea about the governing law, when it comes to governing law, is that the CISG deals with conflict of law principles as well. So for instance, let's say two countries have ratified the CISG, right? And the seller lives in a particular country. The tribunal, where there is a dispute where there is a conflict as to which law actually governs this contract or which law governs this agreement, where the CISG has not been specifically excluded, a party can make a case to the tribunal that because the seller also lives in London or in the UK, then the CISG, because the UK is a party to the CISG, then UK law should apply to that contract and also maybe to the arbitration agreement. So that's the idea of actually specifically limiting or excluding the CISG if you don't want such interpretation or conflict of laws by the tribunal, because the tribunal will be moved to actually interpret that indeed, because the CISG applies to this contract and London or UK is a party to the CISG, or that's an example. That's an example, because I don't also believe that the UK is also a party to the CISG. Yes. So, but Nigeria is not, the UK is not. So, you want to say, a country, maybe Paris as an example, France, is where the seller lives, and no law has been specifically stated in the arbitration agreement, right? No law has been specifically stated in the arbitration agreement. Then, because the seller is closely connected to France or to Paris, then French law will apply to that contract, because that's a provision of the CISG. It deals with such conflict of law situations, and that's why it must be specifically excluded, and you must actually specifically state in your contract that the CISG will not apply to this contract. Because when you really want to make a case, you can make a case to actually find the governing law of that contract and indeed of the arbitration agreement. That's why I was saying again about separability, that the law governing the contract is different from the law governing the arbitration agreement. Those also must be specifically specified, clearly, because when it comes to separability principle, they are not the same thing. For instance, let me use again the P&ID case again. The judge found that the contract was obtained by bribe, right? By bribe. But that is the contract. And doesn't mean they can't go ahead to enforce that award. You can actually get that $6 billion from that contract that was obtained by bribe. You can. But the question is, was the arbitration agreement or the awards themselves obtained by bribe and fraud? So they are two separate things and they must be specifically stated. It's different if the contract was obtained by bribery and fraud, and it's separate if the arbitration agreement itself was obtained by bribery and fraud. So there are two separate things. So the laws must be specifically stated. That's why, the CISJ comes in. I hope that clarifies it.
Yes, Tohib, it clarifies it very much. Thank you.
Yeah,
I just want to ask one very last question, just to grasp it fully. You gave the examples of Nigeria and UK having not yet ratified the CISG. That's
yes.
what you call it. So when perhaps maybe the parties to the contract are closely related to Nigeria and the UK, even where the arbitration or dispute resolution contract does not specifically exclude the CISG, will it still apply since the two countries have not ratified it? Or there won't be any need for that?
So when the two countries have not ratified, it won't apply. It won't apply because I have the CISG in front of me. Because now, if you look at Article Chapter 1, Article 1 of the CISG, it says that the convention applies to contract of sale of goods between parties whose places of businesses are in different states. That's one. And when the states are contracting states, so the two states must actually be contracting states to the CISG. So one party can be a contracting state and the other party can be, the CISG will not apply.
Okay,
right?
So what this means is even where one party is a contracting state, where the other party is not, and it is not explicitly excluded in contract,
it will not apply. It will not apply.
Right.
Yes.
All right.
But where parties, because this is, we are speaking to an international audience, where the parties are CISG contracting states and it is not excluded, right? And no governing law also was stated, then the hands of the tribunal will be tied when an argument on the application of the CISG is presented that we should apply the law of one of the contracting states to the CISG. And this then determines what law governs the challenge, what law governs maybe, of course, the enforceability, issues of state immunity and things like that. So that's why it's critical to pay attention to this.
All right. Thank you so very much, Tohib. Thank you to the audience. Thank you for being on the call. And thank you, Chinelo, for that fantastic question, which is proven to be quite illuminating. So we've come to the end of today's webinar because we are way past time. So come to the end of today's webinar. I would like to say a big thank you again to everyone who had time to join. We'll be having a series of webinars over the coming months. So I'd like to implore you to register for them. And as they'll be quite illuminating and for everyone, and of course, enriching also. So thank you so much for taking your time to join this beautiful Saturday. See you in the next webinar. And of course, let me say thank you to Tohib, especially for taking out time to join, and really grateful. Hopefully we can basically get to have you again in subsequent webinars.
Absolutely.
All right.
Thank you very much. Thank you very much. Thank you everyone for joining.
Thank you. All right then.
Yeah.
Have a nice day. Bye.
Thank you very much.
Yeah.
Thank you very much for this webinar.
Yeah. Thank you.
Thank you, Emmanuel.